In this matrimonial law field,
When do you want? Not if we should.
I want, but this matter should be listed tomorrow because urgency is while your lordship adjourning the matter to 21st July, directing both the husband and wife for their personal appearance, and directed not to disperse the retirement because I have already retired on the 30th.
Correct.
Not to draw the my retirement benefits. But in the maintenance proceeding, the Learned Judge Family Court has directed me to pay the maintenance at the rate of 40,000 on or before 5th of every month.
Take tomorrow.
Yes, ma'am. That is the urgency.
It was mentioned by your Learned Junior.
I have already intimated.
Your Learned Junior took almost 2-3 minutes to mention it.
Mention this. Anyway.
So tomorrow who will mention, please kindly find out. So that there will be 3 mentions for one matter.
That was her first day.
Last day, second day is not. That's not the issue.
One by one.
But you inform the other side?
Yeah.
On the other side.
So the Learned Counsel has signed the memo?
No, I have already.
So we are not changing it.
He is not present. That is why.
Whatever it may be, sir, kindly appreciate this, sir. You have to listen, then you can understand. This is an order passed in presence of both.
Yes,
and in your presence.
Yes, sir.
You want variance of that order.
Yes.
It's not a question of modification. So please inform the other side.
Yeah, I have already.
No, it's not. Signature.
Not signal because he is out of station. That is why.
Whatever, sir. Then you see.
Message at least.
Send message at least.
Yes, I have sent messages through WhatsApp.
Yes.
I have on telephone also.
Okay. Again in the evening at coffee time, just give a call.
That's never very good. Wait up in press admission.
Press admission.
Press admission.
Week after next.
Next week, I don't mention.
Week after next
Sir, is
means-
completely press.
Week after next means 2 weeks.
Yes.
Okay.
MA here 388 of 2023. MA here 388 of
Time. We have abundant time. You need not haste. That haste is not necessary. Yes. 2 weeks. Yes.
Yeah,
But
MA here
take
388
out 2
of
weeks.
2023.
Take the sub memo, please.
My lord, kindly be listed next week.
Next week.
My lord.
Any special urgency?
It was directed to be listed on 14th May. Not listed.
Next week, because we have already, as my brother said.
Please give that indication that by so and so order it was directed, because they don't understand. You are
I have
putting
mentioned-
them into difficulty.
I have mentioned.
You have mentioned? Oh,
Mine.
Very well.
Take.
Press admission matter. Press admission matter may be taken up next week.
Next week. Any urgency or after next week?
After next week.
After next week. Week after next.
Disengagement order of the petition was challenged by this petitioner before the Honorable Single Judge, and Single Judge confirmed the disengagement order on the ground of low performance. The appellant is a very poor person, your lordship, and earlier this matter was before this Honorable Court, and this Honorable Court already directed the state.
When do you want? After 3 weeks? But therefore, we asked you the date. Anyway, after 2 weeks, you have it. Yes, sister.
Page 1, item 1 to 9.
Page 1 don't call for mention.
1 to 9, no.
Page 2, 10 to 13.
Only 2-3 persons.
A little bit louder.
How many?
Your voice can be.
Which is your matter? What matter?
Item number 26 taken 26.
Have you informed the other side?
No, Miller.
You're not informed.
Mr. Sahoo has attending his uncle's funeral.
2 weeks at the request of.
2 weeks after Miller. 2 weeks after.
Yes.
Petition. Public.
At the request.
Item 29, my lord.
29.
Item 29, my lord.
It's appeal.
My lord, it appeal. In this case was last week before your lordship imposed court.
What do you want?
My lord, I want 2 weeks time to file.
That's what. Like a file after 2 weeks.
29.
Post after 5 weeks.
Item 24, my lord. Item 24, my lord.
24.
Maybe taken up next week, my lord. I'm for the appellant, my lord.
You are for the appellant.
I've already-
We'll have it in the first week of July, August.
My lord, may
You
I-
oppose that?
Yes, no, my lord, I'm not opposing to their adjournment, my lord, because they
My
told
statement-
in the morning that Learned Senior Counsel is ill.
Ill.
But my only submission that if it can be taken up next week, my lord,
Next week.
because this is a regulation matter.
Next week.
Next week.
Next week.
Let me-
One day, this side, that side, it comes because clustering cannot happen, na?
Yes, my lord. Actually, what happened? They have dispensed already the services of two
Okay.
respondents.
Okay.
That is the urgency.
Okay.
34, my lord.
34.
In this case, I am applying for opposite party, my lord. Mr. Pathway is applying for petitioner, my lord.
Now, what you want?
I feel this your lordship call this matter after 3 weeks, my lord.
Call in first week of August.
Mr. Patron, no objection?
They have not filed
First week
counter.
of
They have not filed counter.
no further adjournment.
No problem.
For filing objections. Objections.
7, please wait, sir. Already called. It is over. Pending.
What objections?
We are at gone beyond this.
Item number 42, the
Last page.
matrimonial appeal. This Honorable Court directed for appearance of both the parties. My lord, my client is present in court. Your lordship may take up it at 2 p.m. as fast case or
Very well.
2 p.m.
As you say.
As you-
As you say. Appearance all we will take at 2 p.m. because sometimes they have to go back. Sometimes may not reach at all.
Yes.
Appearance, all
All
appearances
personal
at
appearances, please mention at 2 p.m.
2 p.m.
If not reached, of course.
If not reached in the meanwhile.
Lordship, item 38. Please
38. And what you want?
taken to the next week.
22 matter.
Yes, 38.
Have you informed the other side?
I'm there for the respondent.
Can be given. First week of
It's a pray lordship for the next week, lordship.
next week not possible. Calendar is full. Yes.
Item 18, I played for 2 weeks.
Which one?
Item 18.
1-8.
1-8.
Which year matter? 24. Second week of August at the request of.
You are for the appellant. Inform the other side.
If other advocate comes and argues,
My lord, I will inform.
we will take up the matter. And because you should tell them that they need not wait in the court hall. Okay. Yes.
Seven.
We'll call.
If you're in a hurry, then
We'll call.
Item 1.
1 minute on behalf of
preferred against the order passed by Honorable Single Judge on dated 19/9/2024. Mallards, the appeal.
Yes.
Appellant being the petitioner filed the writ application with an object to challenge the arbitrary actions of the respondents and subsequently avail the post of Anganwadi worker under the Ankula Center. Mallards, advertisement was issued, appellant participated, cleared all the stages and was transcribed as highest scorer in the tabulation sheet. Subsequently, respondent number 8 was given appointment, as an outcome of which writ application was filed.
sorry for that.
Score was
79%, which is at page number 23 of my writ application.
and opponents was
68.53.
was there any other condition as to residence etc.?
Mallards, in the tabulation sheet, it was transcribed that the petitioner does not
Can I
reside.
answer? Whether there was a prescription for residence, your answer should be binary, yes or no.
Yes, there was.
You can
There was.
proceed in the deliberation.
Yes.
You did not belong to that place.
No, we belong to that place.
Same place.
Yes. Mallards, after that, the Honorable Court asked us to approach the alternative remedy. In that case, the judgment of Godrej Sara Ali was relied. In Godrej Sara Ali, Mallards, there are 4 grounds upon which, irrespective of being an alternative remedy,
Not alternative, statutory remedy.
statutory
Act finding court, as per the, it's not exactly a statute, it's a
rules, it comes under rules and executive
very
orders.
sure also rules, it is executive instruction.
Yes.
So that is to renew to your benefit. Because
You could have
it
gone
court
there.
and get the facts churned out, then come to the single bench, so that obviously
Because these matters involve some expertise in the governance or in the trade. That trade will not be known to us. But once the tribunal or authority takes an order, makes an order, then we will be able to look into. That is the reason of, if you see, SP Sampath Kumar versus Union of India, 85-86 Supreme Court, perhaps 85-86 Supreme Court. Of course, it is overruled is another. But reasoning as to why one should go to alternate remedy, like tribunal, etc., they will have expertise in the matter, which judges will not be having.
Well, if you read Whirlpool also, it doesn't exclude that wherever there is a more efficacious statutory remedy, that should be given a go by, because that is in your interest.
Well, if the Honorable Court permits, the reason for which the appellant didn't wanted to pursue was the recruiting agency for several years have committed certain dichotomies which are questionable in nature, as an outcome of which it was also suggested by me being a counsel, but the appellant was...
the recruiting agency committing mistake and the statutory appellate authority committing mistakes are two different things.
Well, it's both.
So those continuous mistakes, according to you, can be brought to the notice of the appellate authority. There is no difficulty.
We'll give time to you to approach the alternate, avail the alternate remedy. Okay, we'll keep open all the contentions. And if you approach the alternate remedy, seek the alternate remedy, we'll direct the forum to decide your case within 6 months. All right? This intra-court appeal.
There is a provision for appeal. And subsequently, in amended provision also, second appeal has been provided under the RDC also.
So 2 appeals are available.
Exactly. In the 2 amended.
Anyway, now he has spent some time here. We let him file the appeal within 2 weeks. Within 2 weeks, appeal to be filed. And if it is so filed, within 6 months, matter to be disposed of.
Exactly.
Perfect. Within 3 weeks for filing. This intra-court appeal seeks to call in question a learned single judge's order dated so and so in appellant's WP number so and so, whereby the relief to him is denied on the ground of availability of alternate remedy at the departmental level. First one. Next paragraph. Learned counsel appearing for the appellant vehemently argues that the alternate remedy is only a judicial invention, and that our constitution does not mention anything about alternate remedy, while writ petition is entity. First up, he also says, quotes a decision of the apex court in Whirlpool versus so and so in support of his contention that availability of alternate remedy is not a China wall that would prevent the invocation of writ jurisdiction. First up, next paragraph. One sentence. All this having same sentence. All this having not been duly adverted to by the learned single judge, impugned order is flawsome, and therefore indulgence of this court is eminently warranted. First up, learned AGA Mr. Mohanty, appearing for the official respondents on request, vehemently opposes the appeal, contending that there is absolutely no reason for this court to interfere with the learned single judge's order, who has non-suited the petition appellant for not availing alternate remedy. First up, he adds that even now, appellant can be asked to go to alternate forum in a time-bound manner, and that if reasonable time is prescribed by this court, that appeal would be heard and decided within a reasonable period, should all grounds be kept open. First up, this appears to be fair to us. First up, he also adds that there is not only alternate remedy, if he loses remedy there, there is also an appellate forum for grieving before the same.
Second appellate forum.
Second appeal. That is. He also adds that there is second appeal as well. First up. We agree. We broadly agree with the submission of learned AGA. And therefore, we do not find any fault with the learned single judge in denying relief to the petition appellant. First up. Next paragraph. In the above circumstances, this appeal is disposed of, reserving liberty to the appellant to file an appropriate proceeding before the first authority within a period of 3 weeks. 3 weeks, taking up all contentions, including those that have been urged before us. First up, should such appeal be filed in time, the authority is directed to hear and dispose it of within an outer limit of 6 months. 6 months. By affording opportunity to all the stakeholders. Amen. Ordered accordingly and appeal is disposed of. Amen. Grateful.
Appearing in this case.
In this case.
In this case.
Not ready today.
No.
Not okay. Call this matter in the second week of August.
He's there in the 9/7.
He's in the VC.
I could not connect on the time. This is a case where the petitioner lordships is a person with disability. He applied for engineering entrance in 2024, my lords. And 2024, last year, lordships. And he was issued the admit card, which is, my lords, page 15. And the fifth column from the top reads that person with disability, category yes. Well, subsequently, he qualified with the rank of 2445. He was sent for counseling at NIT Rourkela. Then, lordships, he was sent to medical verification, my lords. Before that,
PWD.
PWD, my lords. Before that, I would take lordships the certificate issued by the Government of India at page 16.
16.
16, lordships. And the ID card issued is 17, page 17. In the first physical verification, lordships, that is dated 15th June 2024, at the bottom, my lords, he is disqualified.
On the ground that disability
below 40%.
Disturb the court proceedings, which is your matter today. You are not supposed to disturb the court proceeding. Kindly be seated. Yes.
My lords, at page 18.
Please do not disturb the court proceedings. Yes.
My lord, sorry, my lord. My lord, at page 18, lordships, in the first physical verification by the designated doctor, my lords, at the bottom, lords will find disability is less than 40% and he is disqualified.
What is the required amount of disability?
It is 40%, my lords.
40%. And the request held him to be?
Less than 40%.
Less than 40%. How much?
Well, that is not quantified. It is written. Disability is less than 40% in the box at the bottom of page 18, lordships. Subsequently, lordships, he goes and gets himself examined at 2 other centers and again reverts back to the same person at that designated examination center. And my lords, at page 21, the same doctor certifies him to be recommended in PWD category.
On the second look.
Second look, after 2 months.
Is there time limit for physical disability?
Yeah. No, my lords. The admission has a time limit. It is on 10th of August, the admission date closes. I was certified as qualified for PWD on the second round on 6th August 2024 at page 21, lordships.
Now, what they say?
They say in the second round that I am recommended for the category of PWD. Whereas then I subsequently try to upload my applications and everything, but the website did not permit me and I was denied admission. Whereas this is the short point involved in the issue.
I think covered by the judgment now.
Please, lordships.
Covered by the judgment also. Who appears for the other side?
No, I'm appearing for the opposite part number 1 and 2.
Yes. 10th August was the last date.
My lord, NIT is
exam committee. J chairman J, are you representing?
No.
Can you take instruction from him? Because I think this uploading has been closed. That is how it is not submitting.
What is his fault? If your computer does error, why should citizens suffer? On 6.8 itself, the certificate says it is above percentage of disability. You take notice.
National Testing Agency. This counseling process is conducted by whom?
NIT Surathkal, Lordships.
NIT Surathkal. In Karnataka.
At that point, it was Surathkal. My lord, I had also sent a representation to them.
They lead this, so it could be Surathkal because it is distributed throughout India. But he has to appear at the NIT Rourkela.
My lords, that was the place.
The center it is.
Local. So then you take instruction.
Issue notice.
Yes.
Issue notice. Shri. Appears heard Shri Meru Sagar Samant, right? First up, a case for admission is made out in as much as 10/8/2024 was the last date for admission, and on 6/8/2024 the petitioner had obtained PWD certificate which vouched his claim that the disability was above the prescribed limit. First up, learned counsel for the petitioner submits that when he tapped the availability, the system, computer system did not function because of, arguably because of its defect, and therefore,
last date,
no, 10/8 defect, and therefore, a citizen, a worthy citizen, cannot be denied right to admission, which is again a fundamental right, a facet of fundamental right, in the light of Rajkumar versus Gulbarga University, AR Supreme Court, so it's a science. Issue notice, learned panel counsels. You are already on record now, sir.
DSGI, I know Mr. Gochat.
It was not admitted. No, that's fine. DSGI, learned DSGI, Shri so and so appears for
Office Department 1 and 2.
Respondent numbers 1, opposite party numbers 1 and 2. And panel counsel?
I'm appearing for OP number 1 and 2.
You are the CGC or senior panel counsel?
Myself, CGC.
Mr. Gochat, I know Mr. Gochat, CGC. Notice to OP3 by speed post.
By speed post.
Take notice. Today you file the requisite or you are unable to follow.
Requisite to be filed.
Extra copy may be served.
NIT you are appearing?
One extra copy.
Yes.
Yes, you give him 2 extra copies.
My associate is there, my lord. Soumya is there. He will do the needful.
Very well. And when to be posted?
My lord, as per Lordship schedule and the admission of a student, Lordship may consider.
Which is the admission, when admission begins? This is for the next year.
This was the last year, my lords. So this year I have no instruction when it begins, my lords. But they can take instructions. So they can get it by email also.
After 2 weeks. After 2 weeks, we call this.
Okay. Very grateful, Lordship.
And notice to OP3 NIT Rourkela by speed post.
Give that judgment. Rajkumar versus Gulbarga University, where Apex Court said right to education. Mental right. Yes.
Item 8.
Right now, just look into one. Other judgments are also there.
Rejection of NOC, Your Lordship.
Rejection of NOC for
of the current academic session 2025-26. Lordship, on the similar footing.
Dream India was before.
Yes, Lordship. Yesterday item 8. It's of the different course, Your Lordship.
Yesterday course.
Yes, Lordship.
BSc nursing.
It is GNN.
Where is that order? Order is.
It has been posted to 10th of July, Your Lordship.
The same order has to be passed.
Yes,
ma'am. Number, read number.
16730 of 2025.
16730 of 2025.
Item 8, fire certificate, etc. That fire certificate and
Yes,
building was not
building,
completed.
yes,
That matter.
Your Lordship.
The same institution and only GNM course.
Correct. Issue emergent notice. Shri, who takes notice for respondents?
Lordship, DMET, Lordship,
Three. Sorry, so panel counsel on request accepts notice for respond. All respond?
2 and 3.
2 and 3. One is state?
State.
Shri, AGA Mohanty accepts notice on our request for first respond.
Registration council? Myself.
1 and 3, Mr.
Asimanti, you require extra copy? No, extra copy there should be.
Yes.
Your Lordship copies.
Call this matter on 10th of July,
Along with that.
along with the other connected matter. Give that petition number.
Yes, I have given.
Okay. Yes.
Item 9.
Please along. Lord, in this case, we are before your lordships. So far as the BSc nursing courses are concerned, because earlier it used to be held by the state government itself. Now it has come under the OJEE, that is the Orissa Joint Entrance Examination.
Even nursing course has come under that.
Yes.
No, entrance examination.
Entrance examination. Entrance examination. But the admission and everything is through the
Plus 2 or 10? Plus 2.
after.
Earlier it was 10.
No, this is BSc.
It was
BSc
not
nursing.
diploma. It's a BSc nursing.
Not
Degree,
diploma.
degree.
This is a degree course.
Previously, it was done by the council. Now, since last year, it is done by this year. It has been given to the OJE for conducting the entrance exam.
Okay. But they follow the, my lord, timelines which are issued by the INC. If your lordships can have a glance at Annexure 3,
Annexure 3, page number?
page number 26.
Yes.
So the entrance to be conducted before.
Sibansi, you are holding.
Yes, my lord. I'm sorry, my lord. That is 18015, Sibansi. I'm sorry, my lord. I should have said.
It's 26.
Digital part is this. It's kind of virtual thing, so you don't get the feel to that opening of all pages.
Your lords,
26, correct.
15 June 2025.
15 June, 1st August 2025, 30th September is the last admission date. Even after, because that is the timeline given, even after the classes have started, they can continue with the admissions.
Classes begin when?
1st of August. Commencement of academic session is 1st of August.
So,
but last date of admission is
after classes.
After the classes.
That's the policy of this.
That's the policy. Anyway, my lord, we can't complain on that. Then your lordships may come to the next page, that is page 28. Because the first note, I'm sorry, my lord, 27, your lordships may come Annexure 4.
Notice regarding
all nursing programs. There, the schedule, like the program was given, what will be the age, what will be the maximum limits and everything, but no dates were given on the first occasion. That was, my lord, came on 25/4/25, right, Annexure 5, page 28.
So 28 is like an annexure to 27.
Is like a supplement
to that.
But it was issued later on. And there the date was fixed for BSc nursing is 10/5/25. That is, my lord, 5th in that particular table.
You're right. Basic BSc nursing.
Yes. And then the counseling schedule was given on right on the next page, page 29, Annexure 6. The notice was given, but no schedule was given at that point of time because the results were not declared.
Results of PUC.
This examination
was not
examination. This qualifying examination, which was on 10/5. The previous page I showed your lordships.
Yes.
So they said the candidates who
expected date of publication of OJE results.
It has been declared later on 12th of June.
12th of June.
Yes. Prior to that, they gave the notice for counseling that those who will qualify So they will follow and they will upload these results and all this. OJE is interested to conduct the entrance, but the SNAC will do the counseling. Now your lordships may, the next page is the result.
Counseling.
Yes. The next page is the result. Look, there were about 23,000 candidates and the number of vacancies. Earlier, last year, it was almost 16,000. Number of seats. But the admission was about 8,000, almost half. So this year, in fact, the vacancies have gone up. It has become now 18,000.
Why are you saying vacancies?
I mean the seats. I'm sorry. Seats. The number of seats have gone up to 18,000. But the aspirants number is about 23,000.
Can they be added? You are simply arithmetically adding those seats of last year's seats?
No. I'm not. It has been increased because different colleges increase their strength and everything. So otherwise it has increased.
New institutions are coming.
So keeping in view the last year's experience, because of this delay, because so far as the other courses are concerned, because why I now coming to the issue, why we have come before your lordships is, so far as the other JEE courses are concerned, their first round of admissions have been completed, counseling admissions, and they know the vacant or the seat which have failed vacant. So that is why they have now issued, if your lordships would come to straight away, page 64, annexure 9.
64. What it says?
That is the second round, that is the second special OJEE. For the seats which have remained vacant after the first round of counseling or the admissions, there will be a second round of examination so that the seats can be filled up. And this came out on 11/6. So far as the other courses are concerned, though the same authority, same OJE is holding all the examinations. But so far as we are concerned, the nursing courses, our apprehension is keeping in view the last year's experience where 50% seats were almost remained vacant or filled up 50%, 50% remained vacant.
Remained unfilled.
So we may not be able to get the adequate number of students if the second examination is not held. So, but the schedule now they are progressing so far as the nursing courses are concerned, because again, there will be advertisement if at all, because now they have come up. I'll just give you lots of the schedule. Just on 19/6, they have come forward with the, I'm sorry.
They are not part of the book here.
No, my lord, it has
subsequently there.
No, though before filing of our petition, but by the time we had prepared, it was not there.
Yeah. 19th.
On 19th, it has been, the notice has been issued. Your lordships may just look at the dates. That is for submissions, not even the admissions. With counseling date, what has been given?
So, Nando, where it is?
My lord, the last, these are the tabular form which is there.
Yes.
If your lordship should see.
The last horizontal line.
Last horizontal line, submission. Submission of online application form and application fees. So those who were declared successful on 12/6, the result when it came out, now they have come forward on 19/6, keeping it to 15/7 for the purpose of submission of forms. Then the counseling will come. Then the admissions. Then the actual vacancy position will be known. By that time, as such, the commencement of the academic session may happen, but the admission date would also may not be sufficient to hold that examination and give wide publication. So why we are before your lordships is to direct the JE on the basis of whatever and the DMT or the SNSC to hold the counseling and the admission in a time-bound manner so that we have adequate time. JE also, because JE has to again reconduct the examination. There are two parts. The counseling.
JE has not included.
No, in that particular advertisement, if your lordship. Because my lord, the admissions are not yet complete.
So are they selective or they are simply excluded nursing?
Yes, the exclusion reason is because the counseling and the admission has not been done by SNSC, by the State Nursing Council.
Probably.
So if that is done in a time-bound manner, subject to your lordship's directions or observation, then that would give sufficient time for the JE.
Let us ask them now.
Yes.
Yeah. Who appears for which party?
I am for the opposite panel 4, Indian Nursing Council.
Sri.
No, INC has given the schedule only, but so far as the examinations are this concern, I think my senior
may not have any grievance at all. You have no grievance against
them as well.
Comparison you have to comparative.
Yes, just for the schedules.
Which will have some, it will
have, my lord. No, I'm not saying that they cannot. I'm saying, my lord, the responding parties would be the State Nursing Council,
yes,
and the JE. JE comes second.
Heard that senior advocate Shri Nanda appearing for the petitioner. First time. A case is made out for admission. First time. Issue notice. First time. The AGA, Mr. Mohanty, is requested to accept notice for
one.
For one.
J, there are panel of lawyers, sir.
Shri Mohanty, panel counsel.
For three.
Panel counsel is requested to accept notice for OP3. 3. 2. OP2 who?
2 is 2 notice because panel of lawyers, Mr.
They have a panel. If your lordship permits us, we'll find out and give a copy to one of the panel counsels.
Where speed post you serve?
Yeah, in addition to it.
All right.
In respect of OP2, steps for notice, usual notice to be taken. And in addition, a copy of petition paper book to be supplied to
one of the panel counsels.
Panel advocates appearing for the said respondent, but said vote. First up. Next. 1, 2, 3 are over.
Or my learned friend is appearing today. So that can
Senior government council or panel council?
Senior panel council.
Senior panel. Give your
Shri. That shown that senior himself. It appears for OP for first time. Pleadings to be completed within 1 week. Since run of time will have its own impact on the cause brought before us. First time. Call this matter. Which date you want? Within 1 week, pleadings to be completed. Simple case. This side or that. Can we do it or not? Which are any other judgment of any other High Court on this matter?
Our own High Court has been there extending time. The Supreme Court had given a timeline also regarding the admissions.
But not in respect of nursing.
Not in respect of nursing. It was in respect of the engineering.
Engineering courses.
For the first time, nursing has been
included because otherwise it used to be held by the respective state governments.
Including is a good step. But also including in JE is a good step.
Yes.
But being effective also.
That is also.
So you simply
what are their difficulties?
My lord, no, my lord, why? Subject to your lordship's consent, because the last date is fixed to 15th. If they can, for the submissions.
Submissions. Not for admission.
No. So if it can be on 17th, they would at least know how many applications or anything, because all are online.
Well,
so 1 week is 10th.
No, pleadings can be within 1 week, subject to the legal issue regarding whether they can or not. But so far as the
17th week,
17th,
so that we will have some statistical data.
Yes,
post admission, post that,
or at least pre-admission, but post the application, online application.
If the data may not how many
because this matter on 17/7/2020.
So that data is to be provided by OJ.
My land friends,
should come up with the data.
That will not be complete because 15th is the opening day.
The last
day.
Last day.
So you will have
Alright.
data.
We should. That is why I said, my lord, 17, so that my learned see they can have that time.
It's in the application for the P3, you'll be having the data, sir. P3 shall provide the data regarding the admissions.
Number of applications submitted.
Number of applications
Data regarding the number of applications submitted
As on 15th,
as on
17th, 2020.
remaining vacancies, vacant seats remaining vacant to be for counseling or public for second.
If at all possible.
What are the seats and how many petitioners, candidates have been there in the list so that we can identify?
Yes. No, because they give
Petitioner candidate in this sense, you are saying who have opted for the colleges.
No, my lord, those who have been qualified, their numbers we will give because from the list. And this seats we have provided for this year. So that we can know the
position at least as on that date.
What
could be the possibility if at all?
They can be representative of the entire, all the colleges.
Yes, one.
Yes.
Including management.
So we are not confining this to only these two petitioners.
No.
It will be for all.
For all. This is for
Students will be going, they may choose to go.
It's like a representative writ petition on behalf of the colleges.
Yes, sir.
This is taken on record.
The schedule, madam.
By the State Nursing Selection Committee dated 19/6/2025. Yes, filed in court and taken on record. By copy of this.
The second matter, the same order.
Same order.
Same order. Your Lordship is right.
Same, even array of 40 same.
Everything same.
Same order.
Page you should have made same actually. Pages are saying one page behind this.
No, even pages are also same. One page.
Attempted.
Both the matters together.
In this case,
So, it's an interpret appeal filed by the state challenging the impugned order at 15/4/2021 in respect of regularization. But here there is a delay, my lord.
Delay of how many days?
The
petition has not been sought, but
8 and
Copy is not given to you. Give copy also.
2 days.
Yes. It's all. Can we condone delay on payment of cost, which you have done? In fact, Apex 14 similar matters said unnecessarily we need not spend one more day for this.
Yes.
All right.
Yes.
Application supported by an affidavit is filed seeking condonation of delay of 869 days in filing the appeal. First off, this appeal is by the state. First, some plausible explanation has been offered in the application supported by the affidavit. First, even in the main matter, there are some arguable points for consideration. First, though learned counsel appearing for the respondent initially opposed the same, opposed the application, now standing tall at the bar on our suggestions, he agrees that application be favored, of course, subject to payment of costs. First off, in the above circumstances, application is allowed and delay is condoned, subject to the appellant paying a sum of rupees. How many days? 800 dollars, 8,000 rupees by way of cost to the 800, 8,000. There is some normative basis. Yes. 8,000 rupees to the respondent within 2 weeks, filling which application shall be deemed to have been negative and so, and as a consequence, appeal as well. Okay.
Copy I will
the
scan.
amount, maybe this amount on after payment may be recovered from the erring officials of the concerned department personally. Yes. You copy also.
I'll do. In both the writ appeal as well as in the.
Item 13.
Your Lordship. When there is delay of 31 days, Your Lordship, the order was passed on 21 to 2024. Appeal was filed on my Lord 27/3. That means around 5 days after the limitation period. However, the certified copy of the order.
You are for whom?
I am for the appellant, Your Lordship.
Appellant?
Yes.
State Civil Supplies Corporation.
Mine.
Yeah.
The delay has been shown to be 31 days. In fact, the order was passed on 21 to 2024. Appeal was filed on 27/3/2024. That is about 5 days after the limitation period. But the downloaded copy was filed, not the certified copy. Certified copy was filed little later. So therefore 31 days. Otherwise the appeal was...
Appeal in computing the period of limitation. What is the rule in your state? From the date papers are presented.
Yes.
Is it?
It was presented on
along with the your online copy which you are downloading.
Online copy I had.
Yes, that will be the unless your rules otherwise say. Our state it is like
online copy part has not been amended. This is a recent development, but I am not sure. Online copy has been mentioned to be counted as.
My Lord, that is not there.
That is how.
What I humbly beg to submit, this is a technical delay. But delay is in fact 4 days, not 31 days because of that filing of certified copy belated.
What is the matter on merits?
The matter is this. At the stage of admission, the writ petition has been disposed of relying upon a order of this judgment of dishonorable court, which is pending in the shape of appeal where the contempt proceeding has been stayed. SLP has been entertained and contempt proceeding has stayed. The issue was whether the departmental proceeding can continue in respect of an employee of Civil Supply Corporation post facto his retirement. In the connected case, the Honorable Single Judge held that in the absence of any specific provision in the Orissa
specific enablement.
Much obliged. Provision in the Orissa Civil Supplies Corporation Employee Service Rule 1993, the proceeding is bound to be terminated. Matter was carried in writ appeal. Writ appeal also took the same view. Matter was carried to the Honorable Appeals Court. I am talking about the connected case, my Lord. Honorable Appeals Court has been pleased to entertain the SLP. I will show the order also and state the content proceeding that was initiated in pursuance of the order of the Honorable Single Judge in the connected case. Now, when this case came out, I appeared on the first day. I said this is the position. But on the first day itself, without even giving us an opportunity to file a counter, the writ petition has been disposed of saying, since the operation of the order, previous judgment of this noble court has not been stayed, only contempt has been stayed, you comply and later on it will be seen. This is what is the order I am before your Lordship. So my humble submission is this is a point and I am demonstrating that Civil Supply Employee Service Rule, there is a provision that the provision
even in respect of retired employee, proceedings can be conducted.
No. It says
applicable.
Yes, this Orissa Civil Service Classification Control Rule is applicable. Once it is applicable, Civil Service Pension Rule is applicable.
That becomes part of your literature. Once your rules incorporate the provisions of state civil service rules,
yes,
that becomes part of your standing order.
Rules. Then pension rules apply. In that event, post facto the retirement, the proceeding will continue. These provisions have not been taken note of.
Now, how that incorporation rule reads?
Yes, Your Lordship may kindly see.
Is it referential? Yes, it is complete incorporation.
Complete incorporation. That Your Lordship will kindly see the provision.
Page?
That is page 55.
Of the appeal or the writ?
Appeal memo?
Appeal memo.
Sorry.
I have enclosed almost everything just to assist you, Lord.
55. Go to 55.
Subject to the foregoing stipulation.
Just give us some.
I'm sorry.
Rules of procedure you are ready?
Mine. And this is the point that was raised in SLP, and it has been pending. It is pending. It has been considered to a point.
This was not argued in the original case. You say just the read court, read appellate court both.
And that I'll show to your Lordship.
They have not dealt with that.
That issue has not been dealt with. Your Lordship will see Annex 4, page 66.
What are subject to? You said subject to stipulation.
Subject to is from Rule 21 onwards. Subject to is Rule 21. Your Lordship.
No, subject to stipulations.
Foregoing stipulations. Foregoing stipulation commences from Rule 21, page 54. Who will be the appointing authority?
Subject to rules supra is one meaning. Subject to foregoing stipulations is another.
That's that way. That your Lordship will consider. That is from discipline, appeal and review commences from page 54, Rule 21, 22, 23, that much. And there is no other stipulation in the rule with regard to these proceedings.
Vacation conduct rules.
Anyway, the expression mutatis mutandis is also employed there.
Where it refers to pension rules, because the other argument would be the civil service rules also doesn't provide for this discipline proceeding post-retirement. It's only in the pensions.
That pension rule, your Lordship will see.
That is there in CCA rules.
It is Orissa pension rule.
No, CCA rules of the state in turn refer to
pension rule.
Yes.
So that I must.
Then to that extent we have to.
So Rule 7 of the pension rule.
So where CCA rules refers to pension rules?
And that I'll show to you. In fact, pension rule refers to that CCA rules.
Yes, it could be the converse also.
Yes. That you will see.
No. He should travel through CCA rules.
Yes.
To the pension rules.
Yes.
That is what
reverse is not true. Because they have not incorporated pension rules.
No, I'll just point out. 66 to back. Just pension rules. That I'll just point out. Pension rule speaks of. My pension rule says that after retirement of an employee, the proceedings will continue. That is what I was. Pension rule will come into picture automatically. Pension rule will come into picture automatically. That is what I beg to submit. That is the point I have formulated.
In fact, GPC discusses this aspect of the matter.
In fact, pension rule permits the continuation of the proceeding post facto the retirement of a government employee. Yes. Yes.
These rules are promulgated.
Yes.
The original article is in mind.
Absolutely.
Therefore,
that is mentioned at the top itself. Yes. Yes. 62. Is it a whole year or rule?
They enact legislation to provide for. In such cases, they go to the statutory. Otherwise, they don't like. There are two sets of rules.
In fact, pension rule came into picture in 1992. And this rule was brought into force in 62. So therefore, this pension rule could not have been there in the
You maybe take us again to interpolation.
24.
Rule 20.
Now that corporation rule, your lordship rule.
Additional rules. Which provided for incorporating the
55.
Think of the law of 1997, Shripad Hon'Ble versus Standard Incorporation. Law 1997, Karnataka. Versus this aspect of the matter is discussed by High Court, wherein I was the counsel. Justice Sahoo state the law 1997 Karnataka is number. Shripad Hon'Ble versus Karnataka Land Urban Corporation.
I have asked her to make it clear. In fact, I think your lordship, some of the gentlemen here, they are assisting in getting immediately the judgments, because I have seen in other courts, I think your lordship is assisted by a research assistant who can get the judgment immediately. Apart from the court master, I think the computer
can review this thing.
Yes.
Law 1997.
I have also
Shripad Hon'Ble was land on the car.
interns now who are getting judgments immediately. Yes. In the evening when I give them issues, they immediately. It's somewhere over there.
We can look at judgment and compact. It is to some extent in your favor.
My lord, here the problem is this. Now a content proceeding has been initiated.
Bring that judgment.
Yes, and that is. My lord. Your lordship.
You are giving the citation.
My lord.
Which may come to you.
My lord. Your lordship is granting a passover, my lord. My lord. Absolutely. But this issue also is an issue to be.
His first time is taken for receiving the judgment from the judge. These are things which should be done in a couple of seconds.
Absolutely.
Then 1997 Karnataka 306.
Yeah. Yeah, it is there.
1997 IL Karnataka 1561.
1561.
1561.
1561.
Shankar Chogoleto.
Yeah, 97 Karnataka.
Yes. Yeah, 1997 Karnataka 306.
Yeah.
ILR is there. 1997 ILR Karnataka 1561.
Pencil
Standard money location. like proper genuine session. Further, all they discuss this one of interpretation also. Yeah. That's what the case.
Item 14.
Wait, please, your lords. Item 14. I am, for the respondent, my lord, I am. Not
56, 460 days, my lord.
5,000. Yes, brother, 5,000 rupees cost will be given to you. Yes, the cost is all right, my lord, but no, yes, I want to oppose, but kindly have a glance to that petition itself. Yes. Pardon? If you say that you are entitled to say that, you are right. But it's our power to reject. Yes, that is always there, my lord. I have no say in this case. Unless, kindly see a copy. Pardon? Yes, that no problem. So, pattern was yes. Kindly, I have only one problem.
But if you want to make this and all that, it will end up in
no cost. No cost. Yes, all right, no problem. Kindly have a, just at the outset, I will pass on my brief. What a copy has been served on me. And what type of petition that is filed before this honorable court. My lord, I am to. This is that is my objection also. One of the objection. I am not saying this is the absolute. This is the absolute objection. I am not saying so. Let me. Yes, let him place that I have an objection. Let him place. It is up to my lord, but. No, I am on merit also. I have a case. I am ready on that issue. But if my lord will hear both also, I am ready on that today itself. No, there is no problem. No. I should ask class. Because this is a delay of 1 year and 4 months. 160 days. Shall I pass on some judgments, madam? Application. Is supported first. Learned counsel appearing for the learned agency appearing for the state submits that in a more or less similar method. State coordinate bench of this court had dismissed state's appeal. And that was carried in SLP number so I know that the bench board, having altered the dismissal, allowed the SLP civil appeal and remanded the matter for fresh consideration with the observation that matter should be heard on basis. You get copy of the also submits that it is only a legal entity which works with the officials and its limits. And this working is on stage-wise basis. And at times, delay is unintentional cause when papers move from one paper to another on one or another. From that, there is a whole part of what I was saying. In the statement of something actually to one of last year there and there are some giving pointers in the main discussion. So what we need to explication is that not yet the consent appeal for the number.
Only this full response.
And that the application, the explanation offered is too frugal, and therefore there is absolutely no justification for favoring the application. First, he also adds that routinely in matters like this, delay cannot be condoned. State being a model litigant. First, he banks upon certain rulings in support of his contention. You can see the following rulings in support of his contention. Next paragraph. Having heard learned counsel for the parties and having perused the paper book, more consent focusing on the application seeking condonation of delay, which is supported by an affidavit as already mentioned above, and having regard to totality of the circumstances in which the appeal is preferred against the order of the learned single judge, we are of the considered opinion that rejecting application of the kind would cause great injustice to the state, which functions in public interest. First of all, the sages of law have told that condonation of delay would not add merits to the case of the appellant to the disadvantage of the others. First of all, after all, what would happen is the matter would be heard on merits and nothing beyond that. First of all, we also take judicial cognizance of the fact that more older matters than this are stacked in the court cupboards and they are waiting for being dusted out. First of all, it is not that if this appeal was filed in time, it would have been heard and disposed of by this point of time. First of all, thus a host of factors favor the case of the applicant. First. Next paragraph. In the above circumstances, this application is favored and delay of 462 days proved in filing the appeal is condoned unconditionally. Okay. Put this matter after 2 weeks, 3 weeks. Give that apex court decision.
My lord, I would.
Mr. Mohanty was banking upon that.
Batch of decision. About some 50 cases have been now remanded again to be heard. So in all them.
I have given some kindly considered.
So they already
this is the report. See, we need not satisfy you.
No,
we give judgment. Our reasonings will give you.
Personal satisfaction is not there, not required also. But to the point of law, may not have take note.
We have passed the order.
Yes.
If you are agreeing,
because I have given it, may not have not seen.
We need not say everything. No, we need not say everything because we remember.
I don't want to disturb the dictation.
It has been dictated.
It is dictated. You may not be happy with that order. Generally, that happens.
Counsel for the respondent relies on decision so and so, so and so.
Said that.
Dictation is there.
Most of the judgments you are citing at the bar are known to me. With humility, I say that. Most of the judgments
Lyric media.
One judgment probably there is a small order of the Honorable Supreme Court from Odisha.
Anyway, that
There the Honorable Supreme Court has held.
So kindly also take copies of those 100 judgments, 100 orders from Odisha, where the Supreme Court has.
It has set aside and said matter should be heard on merits.
There was a delay of only 100 days. Or
No.
I have seen
In one matter, 300 odd days. We have referred to that order also.
That's the problem.
But yeah, generally, brother, I tell you, in the delay, anyway, you have seen so many matters are pending in our court. It is not that if the appeal was filed in time, we would have disposed of the matter, going by the speed with which courts work. Is it? These things are happen. Therefore, generally, Indian courts cannot work like English courts at Scotland. We cannot do that. Many aspects are there. And on merits you are entitled to. On merits you are entitled. And we should not personalize the things. Otherwise, learning process stops. We should learn from you. Perhaps you may also learn from others and us also. The process of learning should go on eternally. We should not get personalized.
One of the petitioner got 3 cases. One of the person is suffering from the deadly disease cancer. Now is hospitalized in
You mentioned
that I mentioned, the third one.
Up.
So, my lord, it is not yet taken up. Can it be next week?
To pay costs because one of his clients is in hospital. All right? I'll take out that condition. It is said that there is no injury that cannot be cured except by costs. Cured by costs. Although costs are not a panacea, we understand. First, that the application alone delay is condoned, subject to the state paying how many, 462 days?
Yes.
4,600 rupees to the which appellant, which respondent?
So the last
Respondent
yes,
within
3 cases, 3.
within 2 weeks, within 3 weeks.
To all respondents.
Huh?
To all respondents.
How many respondents?
No.
Respondent, he said, nah.
3 cases, 3 respondents. 3 cases.
3 separate
3 separate cases. The last man is suffering. Last man is suffering.
Last man is suffering.
Last man is suffering.
Last man
he could not come. He could not come also. So,
Okay, in the
so-
last matter we will do that because he is in hospital.
So
last
only my cost or no cost, I am not in that way.
Yeah.
Can it be taken next week? It can be hard and disposed of also because I have a case on merit also.
Possible because
week of next week.
It is why, yes, last week it was there. My lord, taking note of my submission.
matters have been posted to 7th and 8th.
Every day we are having letters. I saw that this case only this is the plight, my lord. Otherwise, I would not have.
So after 2 weeks,
Can we adjust the date so that
Some date. 22nd, can we take that?
23rd.
23rd.
no place.
No, we said 2 weeks. Nah? He was insisting upon 2 weeks. So get some 2 weeks date. On
18th, 17th.
17th?
My lord,
All right.
any date.
All.
It's a case of regulation, my lord. They saw about 24 years. That is the.
Yes.
Item 15.
May it please your lordship.
Yes.
For starting of the case, my lord.
Yeah.
In this case, I am for the respondent number 1 and 3. But noting says the item delivered address are address 1 and 2 respectively. And I have entered appearance for 1 to 3, my lord.
So that will be taken care of. You need not worry.
I want some time because yesterday I could not go through the files due to my personal difficulties, my lord. I want only some time to go through the file and apprise your lordship.
What do you say?
Then I will not oppose my lords. But my lords said 2 things in this. One is on the last date, my lords, on 15th of July, there is a delay which is shown because what had happened was the order was uploaded. The last order, if my lords may kindly see the last order, which is order dated 15th of July, 2020.
Delay has seen
order.
But I didn't get that clear.
10 and 9 delay. Noting the delay 9.
Huh? 24 days delay.
The registry pointed that out, that actually what had happened, if your lordships would see the last order itself, if I may just...
delay is from.
Yes, Manoj. Well, that's what had happened. I have mentioned, and that's recorded in the order. So and so appearing on behalf of so and so submits that although para 3, my lords.
That's all right. What you should do with the delay?
Lords, I kindly condone that delay in the it's only 24 days. And second, my lords, I was praying for an interim order, my lords, because what has happened is I have not.
No, I am objecting for the interim because I have
kindly object.
Let me complete, man. I'm not saying I fairly said.
Don't object anyone for submitting something.
No, I am not.
So that is happening many a time.
Before that, for that reason, I have stated that I am not ready in this matter.
So you
can be taken up on Monday also. I will make myself ready.
You respond after it completes.
My lords, all that I'm requesting is, my lords, what has happened is
now we condone delay.
Yes, my lords. And one thing, my lords, just subject to whatever my lords say.
They said you could not prepare.
No, I am not saying. I am not pressing also, my lords. In fairness, I am saying. So, my lords, on the next date, what I'm requesting, my lords, is suppose if the matter is not taken up, then I would press for interim orders on the next date.
Very well.
Can I make that request?
I will be ready, I am.
Right now. Application IA number 4810 of 2020.
Only my objection will record.
Just give us.
By the appellant seeking condonation of a short delay of 24 days. The first application is supported by an affidavit. First, although initially learned counsel appearing for the OP number so and so opposed the application, comma. Now he agrees with our suggestion that the delay being very short, comma, the same can be continued. First, in the above circumstances, application is favored and delay is continued. So, when do you want?
Need my lords, let him put in his counters, then he'll say.
Which date?
No counter is no counter. No, if it is bill, what?
No, I thought that, my lords, I have no issues. I know, but
only objection in I will give an
objection. Here is spending time. We're asking you. Which
any day, one week after, any day.
You said you were ready even on Monday.
Monday.
Matter on Tuesday.
Yes, ma'am.
Okay. Briefly observe.
Can it be on 10th?
10th.
8th. 10th. 10th.
Very good.
No? Doesn't.
Item 15.
Problem.
16, Lord, this is a state appeal against the Honorable Single Judge order. And there is a delay, condonation of delay petition is there, Blah.
How many days delayed? Why everything is delayed in your government?
My Lord,
even appeals are not filed in time. What about the common man on the street? If government is not punctual in the court proceedings, it cannot become punctual in the rest of the governance also. How many days delay, Mr. Panda?
is not written like
Then appeal notice you can. Notice, emergent notice, both on main matter and application as well. Returnable within 3 weeks. Requisites to be furnished immediately. That sentence you can enter every bill.
Item 17.
Millet, I am appearing for appellant. May be permitted to withdraw this appeal.
You want to withdraw?
Yes.
Not happy with the court? Why you want to withdraw?
Yes, ma'am.
Why you are entitled to withdraw? Is it because you are not happy with the court?
Millet, appellant already complied the order.
Appellant, respondent has complied with the order.
Both.
Both.
Yes.
Learned counsel, what's your name, madam?
My name is Swagatika Panda.
Srimati or Kumari? Srimati. Srimati Panda, learned counsel appearing for the appellant submits that her client is not pressing this appeal and therefore the same be disposed of as having been withdrawn after granting leave. First off.
Memo.
appeal is disposed of in terms of method.
For total clarification, I issued a letter to the register,
You need time.
Plus, because
This is the other matter.
Yes. Since Honorable Chief Justice is out of session, so photocopy of the DP file has not been available.
You want time?
Yes, 2 weeks time.
When do you want?
2 weeks time.
Short point is involved. We have heard you on that. We wanted to ascertain why.
Your Lordship asked me that right to audience.
Why it was not given?
Not given, my Lord. He has filed a petition for right to audience, my Lord. Thereafter, order that filed by memo that I will not required for right to audience, my Lord. I will sort for documents, my Lord.
Yes, sir. The only point your Lordships on the other day asked him to clarify that because of non-availability of those documents,
whether promotion was
because anybody is affected.
Yes.
So he said that I will get the linking documents.
Lord, it is affected those who have got promotion in 2019. That is.
No, Mr.
Yes.
That was not the query.
Because DPC was available 2019.
Everything is available. Otherwise, this is a file which contains copies of those documents. And other part is that the DPC happened before
2019 it was.
Whatever DPC happened in 2019, and they got promotion, 6% got promotion and joined in the secretary, senior assistant and secretary. Thereafter, on note sheet of petitioner, the Honorable SCJ has revoked that promotion and sought a note sheet from 5 persons that who by relaxing 5 years of experience as per the rules, they got promotions. Therefore, the earlier DPC, promotee of earlier DPC got affected.
Earlier,
yes.
Person to
that
DPC,
is there. I'll start for
Anyway, let them file some you have to make some statement on that.
The exhibit apply to me or with me. If your Lordship want, I can give a copy of that.
Start for the document from registry.
We want some documents from Office of the Honorable Chief Justice. The call in the second week of August 20. At the request also at the AG.
August. Yes, your Lordships are calling in
second week of August 25.
This is July, man.
Therefore, next week we are having. We have fixed many dates now. Otherwise, we would have had in this month only.
Would it be in the 3rd week or 4th week of
August? 4th week of July. Yes.
If my friend wants, I can supply copies.
Meanwhile, you can share all.
Because his retirement is coming ahead. Petitioner's retirement.
Item 22. In item number 22.
Yes, madam.
Diane appearing for the husband respondent. After the decree.
Yes, sir.
May it please your Lordships. Your Lordships may kindly look at.
My Lord Justice, it was Sahoo.
Lordship's order.
No, he was a additional government advocate. Then so much PL cases, your Lordship remember that case.
Post this matter,
order sheet is there
before the bench, in which Honorable Justice Sahoo is not there.
Item 27.
In this case, counter has not been received.
Counter is not received from government. From government, sir. You don't want to find the counter?
I'll file counter. Already filed counter.
I'll copy that.
Just supply.
Record source not yet filed. You have filed E-file.
E-file.
Which date?
That is last 2nd July. 2nd July 22.
Hard copy for lots of.
Yes.
Do you have hard copy?
Yes.
They have. Submitted by the Lord DGA that counter affidavit has been filed on 2nd of July 2020. Had the physical copies of the affidavits are filed in court, taken on record. Copies served on the Lord Counsel for the petitioner. Scanned copy be updated. You have received copy?
Mine.
You want to respond to the counter?
Mine.
Lord Counsel for the petitioner seeks how much time? 3 weeks. 3 weeks time to obtain instruction in response to the counter on behalf of the state. List after 4 weeks.
Item 28.
In this case, 28.
28.
Yes, brother. I pray for a short adjournment because for a discussion with Honorable VC, a date has been fixed to Saturday. So if that can be sorted out there.
Correct. The Lord Counsel for the Appellate University submits that.
And I have also taken consent from my learned friend.
Have taken place during pendency of the appeal. The matter may be adjourned for a short period. List after.
There was me short
About a date. Available date
10th or 9th.
10th not possible because list on 24th.
Well,
24/7/2025.
Item 30.
I am for the respondent. State is the appellant here.
Yes, Mr. AJ.
So here is Miller's challenge, intercourt appeal, challenging the order of the single judge.
262 days delay. Delay is condoned.
Delay is condoned.
Delay has been condoned, my lord.
Lord, delay has been condoned.
What I, before my learned friend starts, I received a brief late. Can I be given 10 days time for preparation? Some new documents has been added to the appeal. I must have to give a response to that.
The second week of August?
My lord?
Second week of August?
Yes.
This is July, sir.
That side.
Yes, ma'am.
Starts with 4th of August.
4th of?
Yeah. So we can order date for you.
8th August.
8th of August, please.
Yes, ma'am.
Yes, the request.
Now there is serial counsel.
Item 31.
Madam, kindly password. One password.
Password?
Item 32.
This is a simple matter. The petitioner is the candidate to the direct recruitment to the post of cadre of district judge in 2023, my lord. He didn't qualify because of the marks secured in the English paper. My lord, we have obtained that copy in the RTI, that is page 31. That he has just secured 45. That is the first phase. First he has given 55, 46, 43, then 42. So she didn't qualify for the interview. But as it appears from the paper, my lord, English paper, that he has secured total 45 marks. But they have given 42. That and now in the counter they have accepted, yes, that is 45. This is if he will qualify in the that in English paper, can be for the interview, he can be appear. That is the only case, my lord. Counter 6, my lord, para 6. They have admitted, because this is everything on record. I have given that entire paper. I have annexed, my lord, page 31. That if all the marks that is been awarded, if that will be added, then it will be 45. But inadvertently,
look at page 31.
My lord.
So the first question is, what is the marks in first question according to you?
45 is the qualifying mark.
No, you are not looking at the brief.
Yes.
Page 31 of the brief, it shows question number, full marks, marks awarded.
Yes.
The full marks in question number 1, how much he has got?
That is their entire paper, my lord. He has got 12, my lord. That is there in 30.
First question, how can it be 12 out of 10?
No, first question.
31.
Oh, sorry. I'm sorry. My lord, that is first question. Entire brief is there. Item cost.
One, my lord.
I think it is 1.
One.
It is scored through and overwritten, so it comes to again 42.
My lord.
It's not 45. So don't know which question you have got more marks as reflected in the top sheet.
12, my lord. That is 4. Question number 4. That is given 9.
9 out of 30.
Out of 30, yes. But it is 12, my lord. Kindly see page
12
30.
has been scored through because
9 is given.
9 is given.
Yes, but in the paper, that is in page 32. Entire paper has
gone through the first examiner, then the second, then the chief.
That I don't know, my lord, a district judge English paper that has been like a kindergarten, 55, 46, 43, then 42.
You reserve your comments whether it is kindergarten or.
I'm sorry for that.
No, let us concentrate on the subject.
Page 32, my lord.
Because if you add 31, then it comes to 42.
Yes.
You are saying they say that it is 45.
Yes, page 32, my lord, 12. I secured 12 marks in the that is the bottom.
Page 32 it can't be.
32.
31.
English learning to answer 4. That he has the
question number?
Question number 4.
Question number 4, my lord.
Question number 4.
My lord, that 12 in the
page 32.
Page 32.
Last but one line.
Yes, he has given 12 marks.
So who has given it, revised it to 9 marks?
So, my lord, I am not.
Who revised it to 9 marks? When it itself says 12 marks.
It was 10. It was actually 10, then it was 10 to 12, then to 9.
9
and there is an initial who has signed it.
And 9 in the first page, but not in that where it is awarded, the marks. It has not been corrected. It is still there.
It is there as 12 only.
Only. And
So
it is
10 has been overwritten as well.
Overwritten as 12.
not overwritten.
Page 32, sir.
Then there are several questions where I will say that they have
Enlarge solicitor.
make it happen.
Outing approval. Now, outing enlarge. And the mark is
Subsequently. It is subsequently. What was the originally awarded?
Zero. It's like this, sir.
Then 1 year.
Now they have examined it and stated in their counter that it is 45.
But this zero being converted to 2 is approved.
Even if it is taken 10. Let us send it for a forensic. We'll send it for forensic examination.
Now you say they have admitted that it is 12. Where they have admitted?
Where have they admitted 12?
Alert?
Where have they?
Where they have admitted in the counter it is 12. Now
not 12. I secured 45.
No, on what basis? 45.
If you will adopt that awarded marks, my lord, entire paper, that comes to 45.
45. Provided the 12 is taken at page 33.
That I am.
Yes. We are doubting 12 itself. We will send this original paper to forensic examination.
Yeah, it is.
What is the basis of that? That's one way of looking at it. But it is not there. Now you are saying
Page 51, that it is humbly submitted that.
Sorry.
If the honorable.
You are leaving us behind.
No, such matter.
Page 41, para 6, my lord.
Because nobody should do it in future. Yes. Send it to forensic examination. Well, if that is found to be interloping, then we can take action against the person who is responsible. We want to know.
Para 6.
Para 6.
My lord.
Para 6, they have left it to the. How can we decide that it is this, that? 41. Scroll to page 41.
That they are one way they are admitting that if it is 45 marks instead of 42.
Just give us a moment. Please to conclude that. You have asked us to conclude.
If we conclude, but how can we conclude 45 instead of 42? Then it should
This can be subjective, sir. This is the objective I answer.
The 30 marks is a question was for 30 marks. And whatever you have written there, your client has written, that cannot fetch more than 5 marks. We read that also. Although we cannot undertake that valuation, we agree. But it is not a case of 0 mark also. It cannot be 0.
So is that analogy?
Maximum 4 out of 10 in the entire class. That's the highest. You seem to start with 0.5 and end up with 4. No, Simu's right, it is 5 marks.
But they have already given.
It can be 0. Is either
if it is taken as 10, even then
9 because
no, assuming that it is 10, still it will not be 45.
My lord, if that analogy, my lord, is
not analogy, sir.
Original
36.
Brother,
my lord, get the original.
Get the original.
I will produce, my lord.
In a seal cover.
My lord, where is that 1 mark? That's my grievance before the lordship. I'm just praying from this side. Where I have given 1 marks initially, that has been made half. 1, then in a small way.
So that will be clarified by seeing the paper.
Yes, my lord.
So, that happens in examination at several levels. So, we do not know how many examiners have examined it, but the standard procedure is sample is taken in like public examination.
But when I add up, it comes to 45. I cannot challenge you against anybody. I cannot submit anything more than that, my lord.
Then you are doubting our arithmetic. We have added up, it doesn't come to 45.
Not arithmetic of on this paper has been.
Look at 31. Look at page 31, it doesn't come to 45. You look at your page 31, you have looked at now.
It is on the first page they have done it, but on the every page.
Because always addition takes place in the first page. And the mark is checked, indicated in the first page has significance.
But the 12 has remained 12, they are not made. But there are 3 times they have.
That.
Lordship is, my lord, I can't, your lord. I have
even it is the.
I obliged because your lordships I also
here also
it is 10.
Then it is made 9.
Then at 2, then sometimes it is 0. So there are several stages. It is academician have seen them.
Let us see.
Examine the paper, not judicial officers.
What? Not judicial officers.
English paper has been
English paper by the English academics.
English academics. That's why this problem.
So produce that.
Yes.
I'll produce that should also include a report that how these stages have gone. Marking process. Note on the marking process.
You have to explain that also.
So you obtain that in writing also.
So far the question number 4 is concerned, madam.
Question number 4 is concerned.
Yes, madam.
That is
they can explain everything also.
Yes.
We can't.
Why so many changes occurred? Why scribbling and other things in such important matters? Page 31.
Yes,
55, 46.
Did that?
That is not in the
55, 46, 43, 42. Was there any gymnastics?
So many changes.
Sashwati Mahapatra for the petitioner, ASC for the opposite party. The counsel for the petitioner brings to notice of the court base 31 of the petition, which is copy of the tabulation for the marks secured in the English paper 3. In paper 3 of the examination into bracket English. See, refers to question number 4, where 12 marks were given out of 30, which has been struck off, and again 9 marks have been given with so that's a signature. with accompanying initial. The total marks awarded reflect it was 55, scored then changed to 46, then changed to 43, then finally awarded 42. It is contended that since the qualifying marks is 50, the petitioner would have qualified by securing 55 marks. Stop. Then she brings to the notice of the court the answer to the question number 4, which shows initially 10 marks were given. Thereafter, in all likelihood, the 0 has been changed to 2, resulting in 12 marks given. The learned counsel appearing for the opposite party is directed to produce the original answer script, scheme of evaluation, along with a report indicating the scoring through of marks in the top sheet of the answer script, top page of the answer script, the initials contained therein, and the reasons for such change of marks as reflected in the answer script itself.
In the sealed cover.
Everything should be kept in a sealed cover to be produced before the court. Next after 2 weeks.
Just to pardon, that in English one required to obtain 45%. In other two paper in law,
not necessary.
The lordship dictated 55. That's right.
Marks. You have secured 55 marks. That was not your argument. But it is not that we are closing your eyes by getting swayed away.
I am not saying I will get.
Look at your page. That was not your argument, but you look at your page. That should be your basic contention.
If we see the originals, everything is
yes, my lord, I have immense faith on that.
So that is not against you. You mean to say that we observe something against you?
No,
it may help you.
It may help you. Yes.
It may help you.
That's the fact may be corrected because in English only 45% is required.
The percentage you have not reported.
Yes, ma'am.
It will be aggressive so that way. It will be aggressive in some sense so that way. It's a way to argue. Yes.
In 1996. Yes. In fact, your lordship was appearing for the petition. By the Land Council for the petitioner that the resolution passed by the Board of Directors of the Corporation in its 74th meeting adopted the Karnataka Civil Service Regulation and made them applicable to the employees of the corporation. In order to properly appreciate this argument, it is necessary to reproduce the relevant portion of the proceeding of the 74th meeting of the board, which reads thus. Subject number 2, adopting KCS rule and allied rules by KLSC. KLSC has framed separate service rules for employees, which has been adopted by the board in its first meeting held on 26/8/1974. These rules came into effect from 9/8/74, but the same have not been approved by the government. When the existing rules are not self-explanatory and do not provide for various contingencies arising in day-to-day administration, as it is, the KLC now, following various provisions of SCSR 1958 and its allied rules, such as probation rules of 1977, a plain reading of the background in which the resolution on the subject number 2 supra was passed shows that the existing rules were found to be deficient in various contingencies arising from in the day-to-day administration of the affairs of the corporation. It is also pointed out that corporation was following various provisions of the rules applicable to the civil servants of the state of Karnataka. It was in the context of deficiencies in the existing rules framed by the corporation that the resolution adopting Karnataka Civil Service Regulations appears to have been passed by the board. The background note to the resolution further shows that the same was passed not with a view to totally supplant the existing rules framed by the corporation, but provided for and covered by the rules framed by it. This would mean that the Karnataka Civil Service Regulations would be applicable only in regard to matters which were not otherwise covered by the rules framed by the corporation. In other words, the adoption of KCSR was not a measure aimed at abrogating the existing rules, or wherever the corporation rules made a provision, the KCSR would have no application. When seen thus, it is apparent that the provisions contained in paragraph 3.18 of the rules framed by the corporation prescribing age of termination of the employees continue to remain in operating.
So the ratio of this decision is, if the rules of other body are incorporated, they, to the extent of not supplanting the rules, but supplementing the existing rules, can be looked.
And furthermore, if anything is available in the rule, that is not to be followed.
But you said your rules have referentially incorporated CCA rules. Is it not? But they have not adopted pension rules. No. Number one. CCA rules also do not adopt pension rules.
Because CCA rule was there long back, but pension rule came in 92 only.
Anyway, if they wanted, they could have amended. They could have said all those things. But pension rules refer to CCA rules. It's a reverse case.
Yes, it's a reverse case.
CCA rules, suppose if the CCA rules were to refer to pension rules, then you would have traveled to CCA rules. Through CCA, you would have traveled to pension. But you are saying our rules have adopted CCA rules. Pension rules refer to CCA. No, how that can be? Where is the link? There is a missing link.
There is a missing link, but possibly the matters in the matter is under adjudication for the Honorable. This link will be decided either way. Because if your Lordship looks at page 115 of the brief, writ appeal, this is the civil appeal pending for the Honorable Appeals Court, where the grounds taken, I beg to point out. This writ appeal, page 150, that this pension rule is applicable. I am not saying there has been any adjudication, but the content proceeding has been stayed, appeal has been entertained.
May I interrupt you? Because you are saying that CCA rules were holding the field till 1962.
No. The state rule came into force in
pension.
Pension rules subsequently came into. They came to be subsequently promulgated.
Yes.
92.
Yes.
92. No, earlier version was there. I think.
77.
77.
Yes.
77. So prior to 77, even this disciplinary proceeding were contemplated under CCA rules.
CCA
post-retirement.
That part is silent. I was trying to find out. So far as CCA rule is concerned, in fact, there is some kind of loopholes and gaps in the rules, in the sense CCA rule possibly doesn't spell out with regard to what will happen to the proceeding which is pending.
Pension rule was preceded by Bihar and Odisha pension rule. The service code is pre-independence. CCA rules came after independence.
Man.
Because under proviso to Article 309.
And service code is notified under 309.
Okay.
Yes, Mr. Malik, you want to assist?
You can assist.
Yes. That is how the...
And this is the point. And your Lordship, only may I just to draw your Lordship's attention to page 115.
115. Whether this aspect is treated by the court which matter went to apex court.
That is pending on the grounds there is with regard to this applicability of pension rule. And that has been
pension rule. No, you have to convince us now. At least now you have suffered an order at the hands of coordinate bench.
Coordinate bench, my lord.
In identical matter.
Identical matter which has been carried to Honorable Apex Court. Honorable Apex Court has been pleased to entertain the SLP.
But state the contempt proceedings. Not state the order.
That is the...
There is difference between...
Yes.
When court stays the order, its presidential power is kept under suspension. You can argue
that.
Number one. Number two, even presidential order is not kept under suspension as against others because interim orders operate inter partes as between the parties.
Absolutely.
If that is so, the presidential power of a judgment would continue unless the apex court says otherwise, which it said in some matters. No court should decide this matter till we decide this matter.
I never said that. I am only submitting. The issue is at present also in session before the Honorable Apex Court.
If you succeed in the Apex Court, if that succeeds, you make application seeking revival of...
No, here what I am praying for, if your Lordship protects me for the time being so far as the contempt proceeding is concerned. Because contempt proceeding, your Lordship sees only based on that which is also under adjudication before the Honorable Apex Court.
No, you are not saying before us that the order that was impugned before the Apex Court is stayed. It is not your case. Because that order operates.
Order operates.
Apex Court stayed collateral proceedings in contempt proceeding.
Yes.
That is not stay of the order.
Absolutely, madam.
Then that order will continue as the precedent, as binding the coordinate bench.
But yes, I am not disputing that. I am only saying now I am in appeal before your Lordship, before the division bench, my lord. Those provisions were not taken into consideration.
What is the pension provision in corporation?
Pension rules?
Pension rules of corporation.
In fact, corporation doesn't have a pension rule in vogue. They get this provident fund and whatever gratuity they have.
Because you only look at page 26 of the writ petition.
Yes.
Annex 7. Last 3 lines. It refers to Odisha Civil Supply Corporation Employee Service Rules 93.
That is there, that I have annexed.
So that service rule, does it refer to pension rules anywhere? Then that takes care of your contention.
No, it refers to CCA rules, not to pension rules. And CCA rules do not refer to pension rules. But pension rules refers to this is like Shina Bora case of the Supreme Court. You can't, Mr. Mishra, to our mind, prima facie, you can't borrow a piece of law from moon and apply it on earth.
Absolutely not.
Unless you have some satellite like thing, that is there only in respect of CCA rules. CCA rules do not refer to pension rules. Therefore, CCA is end of your space. You cannot travel beyond the CCA at all. Suppose if you had incorporated pension rules, then you could have traveled beyond pension rules because pension rules themselves speak of CCA rules. How that aspect is treated in the coordinate matter?
Coordinate matter that has not been dealt with at all. Nothing. Only that the corporation doesn't provide, that's all. They have not even gone to the CCA rule.
Then this aspect this appears to be important aspect. If we write that way, That will help you to take the matter to the Supreme Court there also.
It is not that way. What I humbly beg to submit, my lord, your lordship may decide this issue. This is issue, my lord, your lordship, we have been deliberating in the morning hour and now also. My lord, I will again try to find out, my lord, if at all I can supplement further in this matter, because the two orders of dishonorable court of the Honorable Single Judge has not been dealt with this issue.
Initiated post-retirement or pre-retirement?
Pre-retirement.
Pre-retirement.
Inquiry was initiated pre-retirement,
yes,
but was not completed till he retired.
Yes.
But question is, if an inquiry is initiated pre-retirement, can it be continued post-retirement? Three things.
That will be also.
Three things which standard books on service law like Samaraditya Pal, like V.D. Kulashrestha and Ramajois, they have treated this aspect of the matter. Ramajois says, no inquiry proceeding shall be initiated once an employee retires unless the service rules provide otherwise.
Sanction of the government, post-retirement. That is the rule.
As a limitation period, it should relate to incident which is absolutely not prior to 4 years.
No call over that proposition.
Second proposition is a proceeding initiated against an employee during the service, tenure of service, can be continued even after retirement unless the rules otherwise say. Second proposition. Then third proposition, like Rule 214 of KCSR, our state, Karnataka State Civil Services rules, they have prescribed a limitation period for initiation of disciplinary proceedings post-retirement. The event cannot be more than 4 years old.
Here it is also there.
Similar rules are here.
Yes.
Similar rules are here. That's how perhaps
CCA rules 13, 15, 11. How does it deal with the proceedings initiated during the service and continuance post-retirement?
That I think that is not there.
CCA rule post-retirement nothing.
Silent.
CCA rule regarding to employees, government servants. Once retired, then pension rule will cover, my lord. After retirement,
then the situation is taken care of, because the pension rule would say that proceeding initiated under the CCA rule, but shall continue.
They have not adopted pension rules.
They have not adopted.
Only CCA rules they have adopted. Initiated prior to amendment, but below over post-retirement.
And this is a phrase. This is
that says that
No, but learned thing is that the difficulty was the case was listed today. Suppose I appeared, I said I am appearing. The same day it is disposed of, referring to the other case. That's all. So there has been no counter, no adjudication, nothing.
If law is settled, the question of
those provisions have not been analyzed. That's what I beg. Which provision you are pleased to consider? Those provisions have not been analyzed. So what I am praying for, this is a fresh admission case. If your lordship decides my fate by entertaining it, my lord, then at this point of law, your lordship can settle also for all times to come.
no problem in favor of me.
My lord.
Rule 7 was
My lord, Rule 7 I was referring to, my lord.
Rule 7.
Yes, my lord.
That one speaks of right of government to withhold or withdraw pension.
Exactly. And pension will include also gratuity. That is what has been defined.
Yes, sir.
My
Yes, sir.
lord.
The point is not there. Just read that.
My lord. Your lordship.
Come to 2A.
Exactly.
Person is referring to the last 3 lines.
My lord.
If any department has proceedings,
My lord.
the pensioner found guilty of late misconduct of negligence in duty, the period of his service, including service center and Indian government after retired. So this contemplates a pending proceeding. Yes, sir.
And this is what has been considered 2A. Such department proceeding referred to in sub-rule 1 if instituted while the government servant was in service.
Stop there.
Obviously, ma'am. That refers to CCA rules. And this provision has been exactly taken into consideration by the Honorable Appellate Court while entertaining the SLP.
They have quoted this.
No, not quoted, but that is the sole ground. That is the sole ground taken in the SLP. No other ground. By referring to this 2A.
In the absence of 2A, this brother Sahoo Saab has shown now, perhaps you would not have had case. 2A, I had not noticed. 2A, 271, read with 7 small a.
Exactly, Your Lordship.
That gives an impression that the proceedings can be, always proceedings can be instituted during the tenure of the service. No, nobody can dispute that.
Well, whether it will survive or get terminated.
Whether it commits legal suicide,
yes,
with the retirement of the employee is the question. But this gives an impression that it may not. It may not.
Your Lordship may consider this a point I have raised, my lord. This is a fresh case.
So this is again the main issue, notice and not
My first of all, delay is to be condoned at 30 days. I was saying.
Delay is there now.
Delay
notice has to go.
That delay I had explained.
Correct. Unless notice is
Your Lordship, please.
Sure. Unilaterally, we cannot condone delay.
Your Lordship, please.
Issue emergent notice. Then we cannot grant any interim order also. Because of Raghavendra Swami Mutt versus
I am conscious that if the appeal doesn't come into existence, Your Lordship will not be some kind of pious observation because tomorrow the case is posted as a last.
But where is the you have seen that judgment of the apex court? Uttaradi Mutt versus Raghavendra Swami Mutt.
I cannot dispute that as a counsel. I have insist on the point of view.
Tomorrow contempt is coming up.
Tomorrow. As a last chance. The order is as a last chance. I'm producing the order, man.
No. Please, Mr. Mishra. That's not the issue. Without notice, that has been discussed. So, the same counsel is appearing before the court.
We believe you.
To doubt Mr. Mishra. My learned name, Mr. Santosh Patnaik, was appearing in the writ petition. Now, the content proceeding that has been filed, my learned friend, Miss Amitra Naik, is appearing.
The learned senior advocate appearing for the appellant employer submits, and we are of the considered view that the matter merits a deeper consideration, that what would happen to disciplinary proceedings instituted against a delinquent employee during the tenure of service. Come on, once he demits office on attaining the age of superannuation. He submits that the conduct rules of the appellant corporation referentially incorporate the provisions of CCA rules of the state, and he reads out Rule 7,
1 and 2A.
Rule 7, we can say. Provisions of Rule 7 of pension rules.
Yes, pension rules.
1992. In fact, not adopted.
1992.
1992. In support of his contention that The pending disciplinary proceedings are not interdicted merely because an employee retires from service. First of all, he also tells us that almost identical question is being debated on the floor of the apex court of the country in SLP number.
SLP number, Your Lordship. Just
so and so. And therefore, matter needs still deeper examination. First, we agree with these two. First, in our circumstances, issue emergent notice returnable within 2 weeks. First, in addition to taking usual steps, appellant to serve copy of the petition on the learned counsel, copy of the appeal memo, along with all the annexures on the learned counsel who represented the employee before the learned single judge. First, in the meanwhile, the impugned order is kept under suspended animation.
So grateful, man.
So that nothing prejudicial would happen in the pending CCA contempt proceeding, in the pending contempt proceeding number so and so, which is slated to be
1148 of 2025. I'll give it.
Which is slated to be posted tomorrow before the. Is it before single judge or coordinate bench?
Single.
Before single judge?
Single.
Contempt matters come here in
because decided by single judge, so matter before the single bench.
Okay.
It is as per the assignment.
Yes. Suspended animation.
I'm so grateful, man. And that SLP number is 11925 of 2023. That is at page 129. 129. Only pray if this order can be uploaded.
Yes, yes. We don't go home without uploading the insulin we understand why you are saying that.
Because that sword is hanging my road.
No problem. That sword will never fall upon you.
Obliged. More than anything else, his deliberations gives a lot of happiness and energy. To me, at least personally.
We also learn from all of you.
But this is
discussion. Only by discussion we learn. It is one of the principal modes of discussion. That's called in Western philosophy. That's called Socraterian method. Even in India, it was like that.
1 hour argument during the last hour gave me a lot of energy actually when I went back.
Okay, but we lost energy after hearing you.
I was telling my associates, I said, we should face like this so that things can progress actually.
Thank you.
Item 31.
Yes, sir. But we never send anybody who performs well before the court with the statutes, rulings, jurisprudential material. If they come here and do some natak, we also do natak together and send that back. Yes.
Matter relating to compulsory retirement, my lord.
Compulsory retirement, yes.
Single judge order.
How many years of service he had put in?
I put in more than 30 years.
30 years.
30 years of service.
How many adverse remarks?
No adverse remarks. Not a single one, madam. There are two review committee. There are 2 departmental proceedings. In 2 departmental proceedings, I submitted my reply. I am no way involved in this. They didn't conduct an inquiry, madam. No inquiry
was conducted.
And those 2 departmental proceedings in which I have submitted a reply denying the charges are taken into consideration for only those, madam. There is nothing else.
Are they dropped or they are pending?
Pending.
They are pending.
They are pending. I have submitted the reply. They didn't conduct an inquiry.
How long they were pending?
Proceeding, my lord. One proceeding from 2020, one is from 2019.
What were the allegations?
Allegations are negligence in duty, suppression of facts, disobedience of instructions of higher authorities.
Whether insubordination is a misconduct in your rules.
Yes, but Rule 3 of the conduct rules, insubordination misconduct.
It's a major misconduct because that will breed a lot of mischief in the organization.
But I have submitted the reply denying the charges.
There was a PC Act also. Criminal case also.
Yes, my lord. Business case, but that is also in the inquiry stage, my lord. That was an inquiry stage. And in our rule, my lord, Rule 71 is the rule providing compulsory retirement. It was since Rule 71 does not provide any procedure, my lord. The state government has issued a circular, my lord. That circular I have annexed, my lord, in my writ appeal, also in the writ petition.
Saying?
That circular provided the procedure how a compulsory retirement can be initiated and be passed, my lord. And your lordship say the
punitive or non-stigmatic review, like
yes, all the entire procedure has been provided, my lord.
13 will, if it is stigmatic, it's if it, then it is goes to 13, 15, 11.
Yes, my lord. Stigmatic.
This is like 38 of our proceeding.
Yes. And your lordship say there are two that circular, my lord, I have annexed page 49, annex of 9 to the writ appeal. Page 49, annex of 9 to the writ appeal. Your lordship.
Of doubtful integrity or inefficiency from public service to ensure efficiency in administration.
Page, your lordship, turn to page 51. I would also take a lordship to 2-3 clauses of the circular, my lord. Clause 9 first, my lord.
Clause 9.
Clause 9 at page 51 of the writ appeal. You also got it, my lord?
Yeah. Premature retirement can be ordered.
Can be ordered in public interest only and not as a penalty to the employee concerned. Compulsory retirement is one of the major penalties listed under Rule 13 of the OCS Class CCA rules 1962, and before it is imposed on any employee, the procedure outlined in the said rule for imposition of major penalties must be complied with. Premature retirement
should not be used as a substitute for disciplinary.
Yes, ma'am.
There is 71 Supreme Court, they have said about this.
That is also in page 53, clause 12F. The order of premature retirement shall not be passed as a shortcut to avoid departmental inquiry when such course is more desirable. Page 53, clause F, 12F.
Yes, that is only what Apex Court has said.
Yes, ma'am.
This circular is issued pursuant to Apex Court judgment itself. Though no, they have mentioned that also.
Yes,
Umesh Bhai Patel. So and so.
That is Umesh Bhai. That is entire service record has to be taken into consideration, my lord. Man, I have in 2000 they have passed the order in 2021. In 2017-18, I have got hours, my lord. 7 hours I have got, my lord. There is not a single premature August entry in my survey.
How many years of service you have put in?
I have put in more 30 years of service.
30 years. Was there a 50-year efficiency bar?
Yes, I have crossed it.
You have crossed that.
Yes.
Then
they initiated proceeding at the age of after completion of 60 years, my lord. 56 years.
The second one is 56.
56. 55. I have crossed that.
You have completed that also.
That also.
Then after 55, what is that? What, brother? What fell down from the sky after 55?
In this case, there is an allegation against the petitioner before the Honorable Lokayuta, my lord.
Whether that allegation was there when second review took place in 55?
This is prior to the review. I am submitting my lord. Prior to the review, there was a allegation before the.
Yes, you could have sent him home at that time only.
My lord.
At that time,
my lord,
he crossed that review bar.
Mr. Malik, was there a review after 55 or the first review at the age of 56?
There was at the first review at the age of 56, my lord. That is taken care of, my lord.
To 55,
yes,
crossed, but 56 there is a review.
When these proceedings were instituted?
Proceedings were instituted, my lord.
Prior to that or after?
Prior to that.
Prior to that.
Prior to that.
Yes, my lord.
But review he came out.
Review is elicited in the year 2021, madam.
Review proceeding. The proceedings under which you said.
Department of Proceedings, my lord. One first 17/10/19, 2019, and second Department of Proceeding was initiated on 17/11/2020. The two proceedings, my lord.
So that is, these are subsequent to your crossing that age.
Yes, ma'am.
Then therefore they have compulsorily retired you.
No, I completed the age of 56 in 2021.
Malik, the point we are discussing is that when 50 you were released.
Yes, ma'am.
The employee is reviewed after 50 for the first time when he was at the age of 56, or he was reviewed at 55. Your answer is perhaps not at 55, but first at
56. That is
you can check it. You can check it first. Yes. I mean, don't go be in a haste to answer everything.
It is for the first time into after completion of page 56, yes, 56, my lord. Let us say page 51 of the writ appeal. That is also taken care of in the
identical matter we are treating. Coming week we are pronouncing the judgment. So we will post this matter after that judgment. Identical question.
Questions of law are
identical.
Yes, ma'am.
Okay. Little facts this side, that side are a bit different. But that does not make any difference to your case. So let us see what judgment we are pronouncing. If it goes, you can draw some light from the judgment.
Yes.
Notice is not at order.
Notice.
They have accepted the notice.
18th June, my lord, it was before my lord.
You appear for respondent.
My lord.
Call them. 22nd?
Yes.
Item 35.
33.
Somebody
33 or 33?
33 has just been solved. The issue involved here is not. In 2009, the central government, state government made a circular on the basis of this central government's letter. Reservation for ex-servicemen in technical and medical education.
Admissions.
Then in 2019, central government again gave a circular requesting the chief secretaries of all the states that you include service personnel also. But the state government sat over it, as a result of which the presently working servicemen were denied of the reservation on the basis of the central government's
reservation in job or educational institution?
Educational institution.
Admission to education. That means their children.
Their children. So, this petitioner filed a writ application earlier. But that session having ended, the court declared that no, the issue is left open, it will be decided. Then again, last year also the same issue arose.
Same will happen.
Same thing happened. There was no stay order, and rightly so, how, for one student, how can there be entire process we held up? But the matter was kept pending for consideration so that in future this situation doesn't arise.
Correct.
But the state government, for reasons best known to him, remained silent and didn't file counter. Then it was listed last before
yes, brother, what do you say?
Today they have filed a counter.
They have filed a counter.
Just now they have filed
30th June. Yeah, you want time to go through?
Just now they have been.
When do you want?
He filed a hard copy.
Well, hard copy filed it in the flag at 50 mallet. Lordship's brief last portion ballot with the office road. Delhi, this is a file.
Is there counter affidavit?
I not sure ballot.
Yes, hard copy is there.
Next, let it come next week. This is a small issue. Your Lordship will contend with it. And in fact, central government is the under the union list, defense will fall under the central government. And education is in the concurrent list. If the central government gives a letter,
Letter? By letter it cannot be. Government cannot be run by letter.
No, if it issues a letter regarding reservation on the basis of which the state has to make reservation in educational institutions, and they have been doing it.
Let us, many points are not as simple as you are saying.
2016, letter would supersede the earlier letter of the central government.
No. Where is the law which says if central government writes a letter, the state government, we are in a federal structure.
That's right, Mullah. But about the reservation, about the defense personnel, the entire thing was based on the central government's earlier letter. So in 2016, that has undergone a change.
No, we have understood that. We are asking you now.
So your Lordship says that is it binding? No, that is a debatable question. But if that has been, they have been following the central government guidelines.
We may follow guidelines from English people also. But whether can we be compelled to follow is the question.
No, it can
on our own, if it wants to do, let me.
Another point would be, can there be a discrimination in between ex-servicemen and servicemen?
Let us. Which perhaps this coming week we will not be able to have this. Some other day we will have.
Any date that pleases your attention.
There are 2-3 judgments on that.
Yes.
Of Karnataka High Court, Madras High Court, and Allahabad High Court.
I was trying to get a decision from the Apex Court.
Identical question. Apex Court, I am not very sure that it has been decided. This is.
That's
therefore, in the sphere of, in their respective spheres, they are independent. They are not vassal units, to use words of Mr. Nariman. Wali Nariman said, states are not the vassal units of the center.
I understand that, but not that if...
Let us see. Some arguable points are there.
26. 26.
20?
26.
26 is a Saturday. 26.
Working. You have to see this calendar.
You are looking at August.
July.
25th.
25th.
Let's say, can put it 24th would be all right. 25, 5 days, not uncertainty or thing.
Even on Thursday, there is equally uncertainty. But anyway, we'll have it 24. Yes. You have to just give us material. Whether state governments are bound by the letters of the central government. Whether letters are relatable to the executive power of the union.
All right.
Those things, yeah.
This is for OJE or national?
Medical.
Medical, then NEET.
NEET. Because what he says, children know. Yes, please.
You are assisting the legislature.
Lordship,
No,
I am for
it's
appearing for
central
central
government.
1 and 6.
1 and 6. Your name is shown now?
Yes.
All right.
I am appearing for opposite party now, 5 OG.
Your name is also shown. Okay.
You can write in a piece of paper. They get possibly, then lose the track.
Smile.
Put a kagos de diyo, so lekhi de diyo. Most learned counsel can write on the executive of that. Yeah.
Your Lordship, that director for personal appearance, that matter.
Yes, come.
Item 42.
Yesterday, my lord, directed to pay 1,000 travel allowance to the wife.
Yes.
I have already
paid it.
Yes.
Have you paid it?
My lord.
Counsel for the upper respondent husband has paid rupees 1,000 ordered by this court by yesterday's order.
My lord, I have received the counter affidavit on Monday itself. I seek some time to file.
Recently, that this impacts the whole process of counsel.
Yes, my lord, but yes,
It's an auditor identification.
yes, my lord, unless
Once they deny that you have not published your manuscript, so the case rates there. Because you are now running a risk of wasting most time. Recurring, now suppose we start asking who funded that, I am from the government. Again, you file it with an affidavit report of the court.
in rejoinder, I will file everything.
Not different. Because it's not a case of proving it.
My lord.
You hold the responsibility of filing a wrong document from the court, claiming to be your right.
No, it mismatches the document filed by the opposite parties.
Cannot say that opposite party is producing the wrong. Because you never disclose. And other party did not disclose also. You did not disclose why you are paying a huge difference of 180 marks.
Yes, my lord. Yes, my lord.
This will create a flat precedent by entertaining such petitions with wrong documents.
The documents which was provided to me by the petitioner. It is sharing by affidavit. The petitioner has.
And the petition you have disclosed.
That's why, my lord, I am.
Not saying the topic.
No, my lord. That's why I am paying to 6.
Deposit at lack of or entertaining the which you will get because you did the implication. If you lose, work on that, you can go to the welfare association. It is your choice. You are making very serious allegations and your answers have not been properly valued. You are asked specifically by the court where from because you have not disclosed.
My lord, that's why I am praying to file the rejoinder to.
Once you file it, you cannot support it by rejoinder.
Because
it's not that it stand as maintained, which will control.
why I am submitting before lordship the documents filed by the opposite parties in counter affidavit. It mismatches with the document filed with writ petition. Why must it is mismatched, my lord? after getting instruction.
After the first stage, you mentioned thereafter when you move the petition, you were specifically asked
Yes, my lord.
that why you have not filed the email copy. You can see in the recording also. You have a difficult task, uphill task ahead. The more you drag it,
No. I have no intention to drag it, my lord. I have no intention at all to drag it, my lord. Because unless
email copy, Google doesn't take, I mean, you don't have to obtain and copy.
it is already vanished from the net site.
All of them are smiling.
What instruction I have obtained from my petition? I have just. Yes, my lord. What instruction I have obtained, I am just presenting before your lordship.
I have a copy of your email which you have received.
Yes, I kindly allow some time so that I will file.
Then that will take how much time it takes to see a Utah email and make it?
My lord, unless the petitioner will
It is taking a copy.
Day after tomorrow, my lord. Day after tomorrow. Yes,
But both the answer sheets provided do not match. The answer booklet number and the test code does not match.
But test code does not.
No.
Yes, my lord. Yes. Exactly, my lord. Exactly.
We are not waiting for you. It's your claim.
Yes, my lord. Exactly, I admit that. I admit that, my lord.
You should have not admitted this. You are at one higher level.
It will be adjudicated on Monday. So 35, my lord.
35. Item 10.
Fine.
Item 36.
Appearing on behalf of the sole respondent here, on behalf of Mr. Subrajit Sahoo. I have not received the paper book yet. Wait, appeal my lord against the acquittal. The paper book, not sure. Very old. Very old. The paper book is there, but we have not received the paper. Not sure. My bad. Paper books are there. Yes, well, paper book is there, but
registry has to be paper book and apply to that.
Yes, ma'am.
Get it from the registry.
Two paper books shall.
We'll have to confirm 98 method. People will not get the market.
We do not have the copy. If the copy is made available, it's not.
Registry furnish a copy of the paper
Adela State.
Adela statement. I have also not.
I will do the apologies. Yes, on signals.
But
yes, you have to go there.
yes, but not sure. May I plead for a date on a later date?
Okay.
But on Wednesday it will be because if we will not be able to collect it. Not sure. I agree about it.
What are the offenses?
The 302 minute. Offense 302 minute. Not sure. I'm not well aware of that.
39 minutes. 39 minutes, I need some time to prepare brief because it is a bulky brief around
Not
5
bulky,
pages.
short matter is involved. File.
Very big.
I am not.
Trying to participate in the distribution. Given once a day. Very really urgent matters. If they are not urgent, not mistaken for officer.
Item 40.